Everyone, you all can have a seat. Okay. Good afternoon, folks. Welcome to Division 5 of the Court of Appeals. I am Judge Lum. With me on the panel today are Judge Brown and Judge Taubman. We have just one case today set for our 2 o'clock docket, 23CA1228, Sync 3 v. Tebow. Council table, and I see we have experienced counsel today. Does anyone have any questions?
No, Your Honor. No.
I'm going to highlight just two things. One is, could everybody who is in the courtroom, please, if you have your electronic device, your cell phone, please silence it, or better yet, switch it to off so it does not interfere with our audio system. And we may at times use the names of counsel or the parties if we mispronounce anybody's name or refer to anybody by an incorrect gender pronoun. We apologize and mean no disrespect. If that happens, please just correct us and we'll try to get it right from then on. All right, we are ready to proceed. Mr. Connolly, you may begin when you're ready.
Good afternoon, and may it please the court. Sean Connolly, number 33600, with Matt Simonson of Hutchinson, Black & Cook, for the commercial landlord, Stephen Tebow. The district court ruled on partial summary judgment that a contrived dispute over unused and unneeded parking spaces justified lease termination. We contend that there was no breach, and certainly no material breach, where the tenant was never denied a single non-exclusive parking space while always having full enjoyment of its entire exclusive office space. We ask that this court reverse the judgment in tenant's favor and hold as a matter of law that there was no material breach. 3 key points are undisputed. First, the lease allowed tenant a maximum of 423 non-exclusive spaces, quote, in common with other tenants. Second, the tenant was never denied a single, not even one time, not even one space, never denied a single parking space in a 438 space lot that typically was half full or half empty. And third, this parking lot dispute admittedly had zero impact on tenants' business operations, as evidenced by tenants' own sworn admissions and by its conduct in, after terminating this lease, moving to much smaller space with only 10 non-guaranteed spaces. We therefore believe it's clear that the district court erred. The district court's ruling and analysis is really not even defended by my colleague. The district court said the tenant was guaranteed 423 spaces, correct, and said under an amended site development plan, there are only 233 spaces. That's true, but the amended site development plan has nothing to do with this case because it sets forth a minimum required by city code, and there's no dispute that this parking space always exceeded 423 spaces.
Mr. Connolly, I understand your argument to essentially be so long as there were 423 spaces in the lot next to this building, that Tebow wasn't in breach. Is that fair?
As to breach, and I think our principal argument is materiality, but
Sure.
yes, as to breach, I think that's correct.
Is it disputed how many spaces we have in the lot? Do we know how many spaces are in the lot based on the existing record?
I think we do. Well, 2 points. I think if there's any confusion, that must be resolved on summary judgment in our favor. All inferences go in favor of us as the non-moving party on challenging the summary judgment. But I think we do, Your Honor, and I think the complaint, let's talk about the complaint, the tenant's summary judgment motion, all said there were 438. And I think that's the correct number in a couple of ways. That was the number that on the site plan, the amended site plan, after this whole case arose when there was a reduction of 140 spaces. And it was not even a reduction of 140 spaces, it was a net reduction of 129 because 140 spaces were lost when the property to the north was sold, and then 11 were given back on cross easement. So there was a net reduction of 129 spaces. At that time, I don't think there's any dispute, there were 567 total spaces for the building. And the complaint is that 129 were reduced net. So to get to 438 that way, I think the complaint said there were 438 spaces. The expert report attached by tenant said there were 438 spaces. So, and so I don't think there's any dispute that there's 438. There's a little bit of confusion, a couple of points in the record when, and they seized on it. I think their brief, their opening brief or their answer brief, really the core of it is that there were 438. But a couple of points they suggested, there might have been less than that, and it got there from our client's testimony and deposition. We might have been 11 spaces short, he said, a dozen, I think he said a dozen or so short.
Or so.
I think in context, if you read that deposition testimony in context, he's talking about the site plan, which there are two obligations. One is to provide under the lease the amount of spaces promised. So second, there's an obligation under the City of Colorado Springs Code between him and the city that he has to provide 438. I think the 11 or a dozen or so spaces short would say that we had 423 spaces and we needed, too much math, Your Honor. 438 is the
give you a
number.
calculator, it's
I think
okay.
the number is that 427, we were short of the 438, which was the code. So I don't think there's any dispute, certainly not any dispute that could be resolvable against us that we fell less than 423, which was required at least. But more importantly, your question was appropriately phrased in terms of breach. I think the simplest way is to say that any breach, if we fell below, if we were, let's say, worst case, 11 spaces short, had only 412 spaces instead of 423. I think that's 11. I didn't know. It's a math problem. The hardest problem here is math. I think the easiest problem is materiality. Did it matter? Literally, materiality is, did this matter?
Mr. Connolly,
yes,
before you
Your Honor.
get to discussing materiality, the lease, as I understand it, guaranteed Sync 3 a certain number of parking spaces, and at the same time, there was a provision that said that there were spaces in common. Are those provisions in conflict with one another?
No, I think it's all part of the same sentence, I think, in paragraph 8, that they were entitled, and the 423 is also done by math, Your Honor, and they're entitled to 9 spaces per 1,000 square feet. And we all agree that they had 47,000 square feet at the time. So we all agree that 423 is a number. You're not going to find 423 in the lease. What you'll find in the lease is that they're entitled to 9 parking spaces per 1,000 square feet of office. Shared in common, the word in common with other tenants. So there's really no dispute that these are not exclusive.
But what about the language that says that they're guaranteed those spaces? Suppose there were only like 424 spaces altogether. Wouldn't that mean, as a practical matter, that the other tenants and Sync 3 wouldn't all be able to have their space requirements satisfied?
In theory, it's possible. In actuality, it never happened. That's why we talked to materiality. But in terms of Your Honor's question about breach, no, I think it's critical. And so their lease, like every other lease in that building, was in common, non-exclusive. There's no dispute. And there were 800 some odd spaces of other tenants shared in common. So it's conceded that the alleged breach, Your Honor, arose when this net 140 space reduction, net 129 reduction occurred. And they seized on that to say, now you're in breach. And the original complaint said, cure that by restoring these 129 spaces. So it's always been conceded that these don't have to be exclusive spaces, and that when you say they're entitled to 423 in common, you don't have to provide 800 total spaces for everybody else that has in common tenancies. So they allege so they concede, I think, and without getting too much math, that 567 spaces, which existed, that was the maximum that ever existed before this reduction net 129. They concede that was not in breach. They concede that just because there were 800 total tenancy spaces provided by the collective leases, nobody contends that the parking lot had to provide 800 spaces to avoid being in breach. But I do think the clearest way to decide the case is to say it's just not material. If there was a breach, it's a technical breach. It's a breach that can only be determined by some algebraic formula. They concede, I'm not being rhetorical on that there's no way, given the concession that 567 spaces were sufficient to provide the 423 non-exclusive spaces, even though 800 total tenant spaces existed. They concede that you don't have to give one space. It's not exclusive, so they concede you don't have to provide 423 exclusive spaces.
Did the 800 odd tenant spaces that we're talking about here also, was that, when we're talking about the other tenants, was the same number of sort of total non-exclusive parking spaces shared by all the tenants, was that also in the 800 number when they first entered into the lease? If you know if it's in the record.
Yes, yes. Well, it was. We know it was a whole. When they first. This is what we do know in the record when they originally entered the first lease, they were entitled to 513 spaces because they downsized their offices later on in an amendment. So they were entitled to 513 spaces when at the time there were only 567 total spaces, and we know that there were hundreds more non-exclusive space because they were only 1/3 of the building at the time. It's a 150,000 square foot building. So if it wasn't exactly 800, it was around 800 at all times. And the reason that was not in breach is because they were collective spaces in common. And the reason it was not material is because this parking lot was half full. They never once lacked for a single space. So to say it's material, literally that it matters, it's something that's so of essence to the lease that they can walk away from the lease despite getting all their offices exclusive space, by the way. Their 47,000 square foot is exclusive. That's not uncommon. They have the right to control that. And if somebody infringes of that, they can kick them out, and they never had any infringement. To say they can walk away from that lease when they're getting all the benefits of their office space, and they've never been denied a single space. At all times, there were more than 423 spaces. We would say indisputably, but certainly, to answer Judge Brown's question, certainly when the record's viewed in the light most favorable to us as the party avoiding summary judgment, there are always more than 423 spaces. Never denied a single space. Never wanted more than those spaces. They downsized. They had, they had less than 50 workers on site at the time, which is why they then, after walking away from this lease, they moved into much smaller space with no guaranteed parking and only 10 maximum spaces. So,
Mr. Connolly, with
yes.
respect to materiality, I mean, you're asking us to sort of go the complete opposite direction than the trial court, which in theory we can do on de novo review of cross motions for summary judgment. With respect to materiality, wasn't there a claim by Sync 3 that it impacted Sync 3's ability to sublease the space? And so what do we do with that? Is that a factual dispute? Can we dispose of that somehow?
2 points on that, Your Honor, which I'd like to make. First, talk about the procedural content. You're absolutely right. It's easy. The easy routes just say they're questions of fact. Partial summary judgment should not be entered against us. Materiality is normally a question of fact. So I agree it's a question of fact. Here's why I think in this case you can decide it in our favor as a matter of law. First, on the argument about subleasing impairment. The first thing is legally we think that's insufficient. Under Pomerantz, a decision of this court that was affirmed in part, reversed in part on other grounds, the court said, it was a McDonald's case. I think McDonald's said the alleged breach impaired our ability to sublease. The court said, the division said, as a matter of law, that was not the purpose of the lease. You didn't enter into sublease, so any subleasing impairment didn't impair your use of the lease. So as a matter of law, it's not relevant. As a matter of fact, that just wasn't established. This was, and they cite 2 points in the record for their alleged claim that it was subleased impairment. They had a broker who gave an affidavit, really unrebutted, that tried to lease this for 6 months over 2021 and 2020 and 21, and said that we had no takers because call center uses are just not wanted, and said parking was never an issue. That's his affidavit. Their testimony was we couldn't sublease it because somebody had some interest, but parking was a non-starter. It was just a very general abstract thing that really I don't think raised any question of fact on that. If the court did think there was a question of fact, then the proper remedy in our view would be to reverse the summary judgment, but then not flip the case and say there might be a question of fact of subleasing. I think it's a matter of law. That's not a sufficient harm to satisfy materiality because it's not the purpose of the lease. Their use was never impaired. They never lacked for space. So I think as a matter of law, it fails. I think as a matter of fact, they did not substantiate it. So we'd ask you to reverse the judgment, not only against us, but then as Your Honor said, flip it and say that as a matter of law, this simply was not material as a matter of law. If I could reserve my 2 minutes. Thank you.
Good afternoon. My name is Murray Weiner, 14352, and with me is Bruce Wright at council table. Mr. Tebow bought this 151,000 square foot building in 2020. He proceeded to sell off 4.05 acres, including about a third of the parking lot immediately, all without looking at the lease, our lease. And our lease was for 47,100 and something square feet in the building, so about a third of the building. And the tenants in the other 100, there were tenants in 105,000 other square feet in the building. So looking at this in isolation doesn't really cut it. Paragraph 8 of the lease, and again, this is what we bargained for. Paragraph 8 of the lease, by the way, we operated a call center in the place with millions of dollars worth of electronic equipment because that's what's required in a call center, all these stalls with computers and things. And so parking was crazy important. We're in suburbia, we live in Colorado Springs, mass transit either doesn't exist or almost doesn't exist. And parking is a critical element here. Paragraph 8 of the lease, as Judge Talman said, it didn't use the word guaranteed, but it said shall be entitled to 9 times the 1,000 square feet, which is 423 non-exclusive spaces, as my colleague said. And it also says, and it goes on to say, the landlord can do certain things with its property, but it cannot impair Sync 3's minimum parking requirement.
So, quick question.
Yeah.
How many, well, first, I want to go back to a question Judge Brown asked
Yeah.
Mr. Connolly, which is there a factual dispute as to whether there were 438 spaces available at the time of the lawsuit?
Let me address that directly. First, I'm going to say this is in the first page, the absolute first page of their response to summary judgment below, they said what the issue is, and they said, as the facts are not meaningfully disputed. That's the bottom of the first page of their response to summary judgment. So that's what they told the trial judge. 438 is what we alleged in the complaint. Okay. 438 in their response on paragraph 27 and paragraph 9 both say 438. Their expert report or expert email between them and Mr. Tebow's people says 413, and our expert's report says 419. I think these numbers don't make a difference. In other words, they don't make a difference in the sense their expert email shows 413 spaces, of which 18 are in fire lanes and are improper.
So let me phrase this a different way. Do you agree that there were 438 spaces?
I agree that there's, yes, I mean, 438 or 419 or 413, it doesn't change the analysis of this court, and it's not a material difference.
I think it does change the analysis.
Okay.
So I'm really trying to understand whether there is a factual dispute about the number of spaces.
Well, I guess I would say this. I would say you have de novo review of a summary judgment motion, obviously. But when they tell the trial court that there are no disputed issues of fact, and they concede that there's 438, and I concede that there are other facts in the record of a few different spaces, I don't think they can tell the trial court there are disputed no disputed issues of fact, and they can tell you that there are disputed issues of fact.
But I guess let me ask it from the perspective of their cross motion for summary judgment.
Right.
Do you dispute the number of spaces, right? They're moving for judgment on their claim as well.
I don't dispute that there are any facts, but I do dispute that they never gave any notice, and under paragraph 19 of the lease, they had to give either 5 days or 20 days or 30 days, depending on which paragraph
Okay,
applied.
but I'm sorry,
Yeah.
we're not talking about notice
Right.
right now. We're talking about number of spaces.
No.
Do
Do
we
I
agree
dispute?
it's 438?
Do I dispute that? No, I do not.
Okay. So the next question I have is, how many spaces did they have to add back in order to not be in breach of the lease, and how did you arrive at that number?
Well, I guess I looked at it the opposite way, in that by leaving only 438 spaces for us, which was 423, and then leaving very few spaces for the other 105,000 square feet, it was a violation of the lease. We didn't count the spaces. We knew, my colleague is right, that the 500-something spaces that were there before were not disputed by us. But when you went to 438, we couldn't do business.
So 500, sorry, you go ahead.
I was just going to say, can you help me understand why I'm really struggling to understand, under the original lease terms, as I understand it, there were 567. I saw somewhere else 559. Apparently we can't land on any particular number for spaces in this lot. But whether it's 559 or 567, the Sync 3 was entitled to 513. So roughly 54 spare spaces in the lot. Under the amended plan, right, we have 438 spaces. You're entitled to 423. There's roughly 15 spare spaces. So tell me where in there is the breach, right? Between
the breach is, I hear what you're saying.
I'm
but
struggling.
You can't look at only our tenant, as we laid out in the brief and in the attachment the attachments to the filings, there were 839 spaces committed by this landlord to everybody, non-exclusive, but still, he promised each tenant a certain number of spaces that they could use non-exclusively. So 416 of those 839 spaces were promised to the other tenants, Jackson and these other tenants, the church and all these tenants.
So we're still getting back to what's the number then that would have been
Yeah.
acceptable? Because, when it was Sync 3 entitled to 513 out of 559 spaces,
Right.
they're entitled to about 90% of the spaces, and you still have the rest of the tenants to contend with. And here we're at 423 out of 438, that's about 95, 96% of the spaces, and we still have the rest of the spaces to contend with. I'm struggling in the same way Judge Brown
I understand.
is.
The problem here is I don't think it was our job to count exactly how many spaces. I hate to say what Potter Stewart said about pornography, you know it when you see it, but the bottom line is that when there's only 438 spaces, we only rent 47,000 of the 151,000 square feet, and all these tenants are promised by their leases that were attached to our responses. They're all promised 416 spaces in total, not including us. We knew that we had a problem, and we knew that the landlord had impaired our parking. And we didn't have to wait until Mother's Day, when we couldn't park, the biggest restaurant day on earth and Valentine's Day. We didn't have to wait until we couldn't park our people and get them in our seats in order to be able to not service our restaurant customers in the 9 time zones we service.
Mr. Weiner, regardless of the exact number of parking spaces that were available, do you disagree with Mr. Connolly that the parking lot was only half full?
I don't disagree. My client testified that there wasn't a day when they didn't have a parking spot, but I don't believe the actual use was relevant in any way, shape, or form, because he's looking at these spots not on Mother's Day and Valentine's Day. We have to plan for the busiest day, not January 2nd when nobody goes to a restaurant. So,
But according to the briefs, most of the employees of Sync 3 were working from home even after the pandemic. Is that accurate?
well, what is accurate is during the pandemic, we were prohibited by the governor's office from being able to congregate.
I'm asking about after the
Right.
pandemic.
We were coming out of the pandemic, and we were trying to figure out how we were going to operate, like the court system and everything else. And we didn't know whether we could fully staff. We didn't know whether we'd be remote. We didn't know if we'd be hybrid, or we didn't know we'd sublease. That was the issue. We're coming out of the pandemic, and we're trying to figure out how to go about doing business. That was the problem. That's the sublease issue or assignment issue, is that we didn't know how we'd do business, and we have a giant investment in this place. And we have, of course, there's 438 spaces, and we're guaranteed 423, and there's 105,000 square feet of other tenants who have cars. Let me say this too. We didn't move to terminate. We filed a complaint for specific performance. So we file it, May 11th is the default notice, 30 days goes, Mr. Tebow does absolutely nothing. He doesn't respond, he doesn't comply with paragraph 19F. Nothing, zero.
So let me follow up with that, because I think this sort of goes back to Judge Lum's question, which is, if you sought specific performance, how many more spaces did the landlord have to provide you to be in compliance with the lease?
Well, you're right, we didn't say how many spaces, but we wanted the 140 put back that were there. In other words, he sold that to the neighbor, made a lot of money probably, and the answer is he chopped off a third of the parking lot. We filed specific performance. We paid $60,000 a month during that summer because we wanted to enforce the lease to keep our options open. When the building went vertical, it was obvious that we're not getting those parking spaces back. So we didn't, it's not contrived, as my colleagues said. We were trying to enforce the lease to keep our options open. We have a giant investment. And the lease says what it says in paragraph 8. It is 47,000 square feet. If they took some of those spaces because we weren't using them unilaterally, that would be improper. And if they took some of the outside spaces unilaterally, that would be improper. We just needed, he couldn't impair our parking, and that meant at all times he had to have available for us 423 spaces. I can't say, Judge Lum, exactly how many it would need, but he had to not impair our parking because that's what he agreed to, or his predecessor agreed to in the lease.
And my understanding is there was never a time in which there weren't 423 spaces available. I mean, there's never a time in which.
Not in the record, no.
In the record.
Not in the record.
Can I ask you another question about the record? And this goes to materiality and the question about subleasing. So my understanding is that we had two folks, maybe the CEO and the CFO of the company, testify sort of about these circumstances. And my read of those deposition transcripts, I didn't see any specific reference to, for example, a particular subtenant that was kind of on the hook and then said, well, no thanks, because the parking lot only has X number of spaces in it. I'm not going to lease that space. Is that fair? Was there no actual
There was a footnote. There's a footnote in the brief, and Mr. Johnson, the CFO, received a telephone call inquiring about subleasing it by a call tenant. But this all happened relatively quickly. Remember, the May 11th was the notice. There's 30 days. June 11th is the end of the 30 days. June 24th, we file a complaint for specific performance. And in that period of time, there was a communication from another call center inquiring. But the problem is that it wasn't going to go anywhere without the matching parking that goes with the seat. As Mr. Biggery said, and you saw this, I think, as he said, a call center seat without a parking spot is worth absolutely zero. And that was the problem. They were trying to figure out how they're going to do business in the future. They wanted the lease as written enforced because the full, either go back in full or go back hybrid or go back remote. The court system was doing it too, trying to figure out how we're going to go about doing business in an era when we've never been through this before. And my client wanted, it's crystal clear, he wanted the lease as written, and that's why he filed a complaint for specific performance. Let me just touch on that Pomerantz versus McDonald's case. What that case actually says is that the lease says you have to have destruction or demolition in order to have a default under the lease. And then it said subleasing wasn't that. So that's what that case said. And I don't think any of these other cases, they're all sui generis. They all have their own leases. They're all fact patterns. The cases they cited, they went to trial. They're not apropos. And the Carter case that they cite, they repeatedly say that it was a trivial breach, the case says it was a trivial breach, and there was no statement about a trivial breach of the 1.7 acres that was reclaimed. The court said there was no damage. It didn't use the words trivial breach or trivial in that statement.
Quick question, sort of along those lines.
Yeah.
Do you agree with the concept that even a material term can be breached in an immaterial way?
I do.
Okay.
I mean, I do.
Like if you were denied one parking space
For one
Yeah,
day.
for one
no,
day.
I need to keep my
breach.
credibility. I'm not going to argue things like that. I'm trying to say to you that this business was a call center. This business had millions of dollars of equipment in there, and there's a reason paragraph 8 is paragraph 8, and there's a reason it says you can't impair. And when you go down to 438 spaces and you promise us 423, and you still have 105,000 square feet of other tenants, we got an unbelievable problem.
Under that interpretation, what work is the word non-exclusive doing, or in common? What work are the words in common doing in the lease?
To me, it means you can't. These spaces are Sync 3. These spaces are the church. That's not, anybody can park anywhere, but the landlord still has to provide a minimum shall be entitled to a minimum of 423 spots.
So if every lease said that, wouldn't all the leases have been in breach from the outset?
No, I don't think so, because the answer is that it was the act of how things were operated. In other words, that could be true. Okay, that could be true, but the bottom line is that it was how things were operated. The landlord, the prior landlord, made a calculation, I suspect, that if he had 500-something spaces, he'd be able to service everybody, even though he promised all these people. I mean, I'm not the landlord, but he promised all these people, as you can see in the brief, 839 spaces, access to 839 spaces, not the spaces themselves. So the answer is I think it's how it worked in practice. When things got overcrowded, the landlord would have to take action, because he promised in contracts, not in a zoning and an amended site plan. He promised that. I see my time is up, and I apologize for going over.
That's okay, thank you.
Just a couple of brief points if I can. The issue of a breach is a very technical one to figure out how many spaces are necessary to comply with the 423 non-exclusive spaces really requires algebraic formulas and kind of how many angels can dance on the head of a pin. It's a very technical claim of breach. And I think, given how technical it is, I think it really flows right into the materiality issue. If it's so technical that it's hard to identify what was the breach and how many spaces would you have to satisfy your obligation to provide 423 non-exclusive spaces, if that is so hard to answer and so abstract, then I think it cannot be a material breach. And I think to look at materiality, rather than look at these abstractions, the best way is what happened in practice. And there was no material impact. There was no impact at all. And finally, if I can just answer Judge Brown, I think you've primarily focused on, in the one maybe everybody's asked about the subleasing. I think their only support for that is on their CFO's testimony. I think it's 331 of the court file, said, if I wanted to sublease the space, I would have had a problem. And I got a call, somebody was interested, but then a lot of rhetoric that a seat, they call it a call center seat, without a space is worth zero. It was kind of more rhetorical. There was really no concrete factual evidence. If they want to say that subleasing harm is a legally cognizable harm, which we dispute, and they want to say that we raised a question of material fact about whether we suffered subleasing harm, this record doesn't do it. The pages they cite just don't support that we had a concrete offer, indeed any offer for subleasing the space that said, I'd like to do it, but I can't take on a call center with a half-empty parking lot. That it just never happened in a concrete way that we submit could carry their burden to oppose our cross motion on summary judgment on that ground. So we'd ask the court not only to reverse, but then to reverse with a holding as a matter of law that there was no material breach. All right, thank you.
Thank you very much, and thank you both counsel for your excellent arguments. They will help us resolve this matter. The case will stand submitted and a written opinion will issue in due course. And since that concludes our oral arguments for this division today, the court will be in recess and the bailiff will so announce.